Okay, we are going to start with approval of meeting minutes. Kathy has sent out January 11th, 12th, and 13th. I think you've all had a chance to give feedback on those if you had any concerns. We good? Is there a motion to approve those minutes?
So moved.
Motion by Representative Ralph, second by Representative Schreiber. Any discussion? All in favor, say aye.
Aye. Aye.
Motion, all opposed, say no. Motion carries. Next, we have requests for bill introductions. Any committee member with a request? Don't see any in person. Don't believe I see any online. Let me change my layout a little bit. I do not. So in person, I think we've got several groups, so come on up. Yeah, go ahead, Mike.
Thank you, Mr. Chairman, members of the committee. Mike O'Neill on behalf of O'Neill Consulting. A bill I've worked out with the Kansas Insurance Department, 22 RS 2609, that clarifies the circumstances under which a hearing is required under CAPA upon request of an affected party of a KID order.
Well, it was on behalf of O'Neill Consulting,
Yes.
Correct?
Yes.
22 RS 2609?
2609.
2609. My writing's not very good. Any questions, committee?
Yes, Mr. Chairman, Representative Carmichael.
Yes, Representative Carmichael.
Might I inquire of Mr. O'Neill if O'Neill Consulting is offering this bill on behalf of a client, or is it on behalf of Mr. O'Neill's LLC solely?
It's not an existing client. It became known to us as a result of two prior cases, and we've agreed that it needs to be, for future cases, it needs to be clarified in the act when the CAPA applies and when hearings are applied. So this is on behalf of my LLC.
Okay, thank you, Mr. Chairman.
Okay, not seeing any objections. We will get that one introduced. Thank you.
Mr. Chairman.
Marisa Bayless, Deputy Special Counsel to the Chief Justice. I'm seeking introduction of 22 RS 2682. This is a bill regarding court services officers' duties concerning supervision of certain persons and placement of children in need of care with CSOs.
Any questions, committee?
Mr. Chairman, Representative Carmichael.
Yes, Representative Carmichael.
I'm sorry, there was a technical failure and I could not hear the beginning of her remarks. Who is she offering the bill on behalf of? I apologize.
No problem. My name is Marisa Bayless, Deputy Special Counsel to the Chief Justice on behalf of the Judicial Branch.
I can think of no better people to bring a bill to the committee. Thank you, Mr. Chair.
Okay, seeing no objection, we will get that one introduced. Come on, Jeff, you're next.
I am Jeff Wagaman, representing the Kansas County and District Attorneys Association. We have two bill introductions for you to consider. The first one is 22 RS 2657, concerns hearsay in testimony through two-way communication. That's RS 2657. The next one is 22 RS 2714, an act relating to violence in the presence of a child.
Any questions, committee? Objection? We will get those introduced.
Thank you.
Thank you. Anyone else? Okay. We will move on to bill hearings, and we have two today. We will start with House Bill 2364. Open that hearing and have an overview by Natalie.
Thank you, Mr. Chairman. House Bill 2364 would define the term torturing for purposes of the crime of cruelty to animals. The bill amends KSA 216412, that is the crime of cruelty to animals. Current law in subsection A1 provides that one of the unlawful acts that is covered by that crime is knowingly and maliciously torturing any animal. Subsection I, then later down in the statute, provides for the definitions to be used throughout the crime. And this bill would add a definition of torturing, which would include, but not be limited to, confining or restricting an animal in a way that is likely to cause death. And I can take any questions.
Any questions, committee? Representative Hoheisel.
Thank you, Mr. Chair. Thank you, Natalie, for that overview. Just looking at this, is there exemptions for, let's say, agriculture or anything like that? I mean, or livestock industry?
So let me look at the,
Because, I mean, confining or restricting an animal in a way that is likely to cause death kind of is what business they're in, I guess.
sure. Okay, so if you look on page 2, starting at line 29 in paragraph 6, there is a provision that's specifically related to farm animals that provides that they can be cared for in the practices common in the industry or region. I'd have to look more closely if there's any other specific exemptions
Do we,
for that.
under this, I don't see any description for what a farm animal is. Would I have to find that in another statute?
I suspect that that would not be defined in the criminal code. I can look that up. You know, we have definitions here that are specifically used for this crime itself. We also have KSA 215111, which is the general definitions for the criminal code. I suspect if I go there, that farm animal is not defined, but I will take a look at that.
Thank you, Natalie. Thank you, Chair.
Yes, other questions? Representative Wheeler?
Thank you. Natalie, perhaps you're not the one, but I'm thinking of the person standing in the courtroom trying to present evidence that something is likely to cause death. Can you give me an example of something that might be?
I mean, I think that's a reasonable, as a former prosecutor, you know better than I do, Representative Wheeler, that that could be a standard that could be difficult, I think, to prove in a court case.
Thank you.
Any other questions? Double check online. Okay, thank you, Natalie. We will begin with proponents. First one I have listed is Midge Grinstead. Probably.
So sorry.
You should just, we need a big like
Technically
green button
challenged.
that says on or something.
Well, thank you, Mr. Chair and members of the committee, for the opportunity to speak to you today on 2364. My name is Midge Grinstead. I'm the Kansas State Director for the Humane Society of the United States. I support this bill. Prior to working for HSUS, I was the executive director of the Lawrence Humane Society for 15 years. During that time, we saw many, many cases of animals that were starved to death that were then treated as a misdemeanor instead of a felony when it was purposeful and intentful. And to my reasoning, that's what this bill is about. Under the current law, it says failure to provide, and that's a misdemeanor. So I'm going to go through a couple of cases with you very briefly and tell you why that should have been a felony charge. The first one was a case of a divorced couple. There was a dog that was owned by both, but residential at one of the spouses. They continued to lie to the ex-spouse, saying it was with the ex-roommate. They lied to the neighbor, saying it was with someone else. And this went on for about 3 weeks. And when the dog was discovered in a basement attached to the garage, it was originally a 61-pound Dalmatian contained in a carrier that now weighed under 20 pounds. The dog survived, I think, because to cover up the smell, the person thought the dog was going to die, and to cover up the smell, they threw bags of trash down there to cover the carrier that it was in. It also was in a carrier without a bottom, so it was a wire carrier, and it was touching the floor, so the basement leaked, and water came through, and the dog was able to get water. This person was charged with a misdemeanor, even though I was able to prove that they lied to numerous people on numerous occasions that the dog wasn't there. It was their intent to make sure that that dog didn't survive. And they knew it wasn't eating and drinking because they weren't going down there to take care of it. So that was the first case. The second case was one of, and there are many, these are the two that have stuck with me the most, I guess. There was a young man going to Boston College. He asked his father to watch his 2 dogs for him. Dad said, sure, I'll do it. The son purchased food. The food was in the same room as the dogs. The dogs were in wire kennels. I got a call from an individual who was delivering something to the home, and he said he could see 2 dead dogs in kennels. So the police and I went out there, and I thought there were 2 dead dogs in crates. It was just skin over bones. And I was shocked to see they were alive. They had to be euthanized. The vet chose to euthanize them immediately. And the owner or the father was charged with a misdemeanor. Now, he had to enter the home. He had a walk-in basement, and he entered the home and walked by those dogs every day. He saw the food there every day, and he chose not to feed them. This happens across the state all the time, and I can tell you that we had a meeting last night with animal control, and they were all talking about this, and you're going to hear from some of them today. The issue is that someone who is neglectful and harmful to an animal doesn't stay there. Violence doesn't live in a vacuum. It grows from there. So the FBI has used this kind of profiling for years, since the 70s. They started with serial killers, and now they have a database that has all adjudicated cases of animal cruelty and neglect, because it's such a prevailer of people committing crimes later. If they commit crimes against animals now, they're going to continue to commit crimes later, and that's why they follow that. I hope you'll really talk to some of your shelters, rescues, and animal control officers in your community so you can hear what they're facing with this. But in our mind, what we've heard and what we've seen is that the food issue is the problem. If you fail to provide food and water, then it falls under misdemeanor, no matter what. And I think there should be, that should be looked at, and it should be changed so we can adjudicate those cases where it's knowingly and purposely done. Thank you. I'd be happy to answer questions.
Any questions, committee? Representative Samsel?
Thank you, Mr. Chair. Thank you for your testimony today. With respect to your first example, would that fall under A1's definition of torturing?
You know, I thought it did, and there's also knowingly in there, but we haven't had a prosecutor that's prosecuted a case like that in Kansas that where the animal did not have food and water, because that one sentence says failure to provide food and water.
Oh, okay, down in A3?
Yeah, it's 3.
Okay, it struck me as I read this, A1 only requires torture, whereas the definition, I almost wonder if that increases the threshold. As my colleague to my left noted, it puts a new threshold in there of proving also likely to cause death that didn't seem like it was in there in A1. So I was just curious, because it looks like A1 would be a felony if they could prove just the torturing.
Yeah, so far there hasn't been a case.
Okay, thank you, Mr. Chairman.
Representative Hoheisel? Oh, you're good? Glance back online. Okay, thank you.
Thank you.
Next, and I think they're in the same window on WebEx, Christy Fisher and Rick Bailey. You guys are muted, I believe. There we go. Oh, still not hearing you though. Keep talking. No? Any thoughts on why we're not hearing? They're not muted, right?
Can you hear us now?
Oh, I can hear you, yes.
Okay, thank you. Thank you, Mr. Chairman, and members of the committee for the opportunity to speak with you today on House Bill 2364, Bowie's bill. I'm going to have Christy Fisher start off. She's our executive director of the WAL, and she'll give you a little more information about her background.
Good afternoon, and thank you for the opportunity to speak. As Rick said, my name is Christy Fisher, and I'm the executive director of the Wichita Animal Action League. We're a nonprofit animal rescue located in Wichita, Kansas, and we were founded in 2013 with the mission of basically saving animals in crisis. Just to give you a little bit of an idea about my background, I'm also a former law enforcement officer for the Sedgwick County Sheriff's Office here in Wichita, Kansas. I also am a former animal cruelty investigator, as well as being an instructor for the National Animal Cruelty Investigator School, where I travel across the country and teach law enforcement and animal control officers how to investigate animal cruelty cases. In addition, I also have prior experience running a municipal animal shelter and being in charge of field operations. So this also is something that hits close to home because I have absolutely seen these cases and wish they had been prosecuted differently. So WAL got started trying to broaden the definition of what behaviors would fall under the subsection for a felony under the animal cruelty statute because of the dog named Bowie. So for those of you that may not know, in January of 2020, Bowie was placed in a kennel next to a dumpster in below freezing temperatures, pretty late at night in the dark. And obviously, except for the fact that he was discovered purely by coincidence, he would have died, whether that was from the elements, whether that was from starvation, or whether that was because he would be crushed by the trash truck when it came the next morning. Thankfully, a Good Samaritan contacted the authorities and action was taken to free him. So Bowie came into our care. He was approximately half of the size that he should have been. And it took months of rehabilitation for Bowie to recover from what had been done to him. He has now become the ambassador for our campaign that's Be Loud, which encourages citizens of Kansas and beyond to speak up when they suspect cruelty and neglect is occurring to animals. At the time, Sedgwick County District Attorney's Office told us that Bowie's case could only be charged as a misdemeanor. However, we believe that it should have been charged as a felony, which is one reason that we are fighting so hard to broaden this definition of the felony aspect of the state statute. We believe that we have significant community support for this, both in the Wichita area and beyond, as evidenced by our followers and also by Bowie's followers.
The amendment that we proposed is intended to clarify what behavior can be charged as a felony to give prosecutors more flexibility in charging particularly egregious behavior as a felony rather than a misdemeanor. What we were told was that the specific language in A2 and A3, where it specifically addresses knowingly abandoning an animal or knowingly failing to provide an animal with food, because that language was so specific that it overrode the more general language in A1, which defines a felony. So what this proposed amendment is intending to do is to broaden the definition of what torturing is to include this kind of behavior. And specifically what we say is that it, quote, includes but is not limited to confining or restricting an animal in a way that is likely to cause death. Now, the acts of confining still has to be done knowingly and maliciously. So what's an example of what we're talking about? Well, if somebody intentionally runs their cat over with their car, that would fall under Section A1 of knowingly killing an animal. But currently, as the law stands, if that person takes that cat, puts it in a bag, ties the bag shut, and throws the bag out into a busy street with the expectation that the bag will be run over by a car and a driver who doesn't realize what they're doing. Currently, that would not fall within the scope of killing, maiming, torturing, or mutilating an animal because that person is not directly causing that to occur. Under the proposed amendment, by confining the animal, by putting them in a place where they're expected to be killed, the amendment in Bowie's law would cover that and would allow that behavior to be charged as a felony. In either situation, the maliciousness of the act is the same, but currently one of those is treated as a felony and one is only treated as a misdemeanor. Likewise, if someone were to take a dog in the country and shoot it, that would fall under currently the scope of A1. But if they took that dog in the country, tied it to a stake and left it there, exposed to the elements, unable to get food or water, and unable to protect itself from other animals, currently that would only be charged as a misdemeanor. But under Bowie's amendment, this would allow that behavior to be charged by a prosecutor as a felony. As you know, Bowie's law has been reviewed and it's going to have a negligible financial effect, fiscal effect, and no increase in prison admissions. The current exception for normal or accepted practices of animal husbandry still applies to the same scope that it currently does. This amendment only increases the definition of torturing and would not otherwise cause exposure to ranchers or farmers for any of their normal practices. I'd be happy to answer any other questions that the committee may have as to the scope or application of this.
Any questions? Representative Wheeler.
Just a quick one. Is there an exception for beef slaughterhouses?
I don't know that there is an exception that specifically uses that term, but I know there is an exception for, I'm looking for it here, the normal accepted practices of animal husbandry. And again, even whether there's an exception or not, since this language defines torturing, and torturing is a term used under Section A1. A1 requires for all the provisions that are there that the action be done maliciously. And maliciously is defined already in this statute as having an evil-mindedness or specific intent to do a harmful act without a reasonable justification or excuse.
You repeat all the time that killing a cow is evil and malicious.
Well, there may be some that share that view, but I don't believe that most prosecutors would share that, or most juries in the state of Kansas, as long as it's done in a typically humane fashion. My wife works for a large food company that has slaughterhouses all across the country, and I'm familiar with the practices that they use there. And it's certainly not our intent to have, by simply increasing the scope of the language torturing, to pull any of those practices within its scope. And I don't believe there's been any action that I'm aware of in the state to try and have current slaughterhouse activity fall within the definitions of either felony or misdemeanor charges under the cruelty statute as it currently stands.
I can appreciate that, sir, and I do appreciate this bill and its amendment. I just happen to be from Garden City, where we dealt with that issue all of the time. Thank you, sir.
Representative Samsel.
Thank you, Mr. Chairman. Short question. I note that we've got opposition testimony from the Kansas Livestock Association, and I'm curious if any of the proponents spoke with KLA regarding their what they've mentioned in their letter.
We were just made aware of their opposition early this afternoon prior to the hearing, so we've not had an opportunity to speak with them. I've read their opposition, and it appears to me that the nature of their opposition is not to this particular language, but that they think that this language may be a first step towards more action being taken, or that this language could be misused or misinterpreted by a prosecutor or an activist to try and otherwise bring normal slaughterhouse and husbandry activities within the scope. That's certainly not our intent, and I don't think the language goes that far. This language simply gives prosecutors discretion that in an appropriate case where the prosecutor believes that the action has been maliciously taken to deprive an animal of food or to cage an animal in a way that the animal is placed where its death is certain to occur, the prosecutor would have the discretion to make the decision to charge that under a felony in those situations.
Thank you. Thank you, Mr. Chairman.
Further questions?
Yes, Mr. Chairman, my hand is up.
Oh, I see that. Representative Carmichael.
Thank you. This is the kinder, nicer John that I reminded you all of a while back. First, I would like to make a disclosure of interest. Mr. Bailey and I practiced law together at the Conley, Schmidt, and Emerson firm in Wichita longer than either he nor I would like to disclose to the committee, but it's been many years now. Mr. Bailey, I would like to turn your attention to the question. I believe it was from Representative Wheeler. It may have been Representative Hoheisel, but concerning the element of this proposed amendment to the crime requiring that, I believe the words were, death be likely to ensue, or words to that effect, and whether or not likely to cause death was defined, at least within the statute. My presumption would be that in order for there to be a felony conviction under this provision, the likely to cause death would be an element of the crime, which would have to be proven beyond a reasonable doubt at trial. And most likely that would perhaps be the subject of expert testimony as to whether or not particular circumstances were likely to cause death to the animal. But my presumption may be very wrong. So I would appreciate it if you could address that concern for us.
Sure. Thank you. I don't believe that expert testimony would necessarily be necessary. These cases are all going to be very fact-specific and fact-driven. For example, the examples that I threw out initially of tying a cat in a bag and throwing it out onto a busy street. That's not going to require an expert testimony as to what the likelihood or percentages of objects thrown on a street are actually hit by a car or not. I think that's something that jurors in the ordinary exercise of their prudence and reasonable inferences that they can draw from the evidence could come to that conclusion. But you are right in that this would be an element that would have to be proven beyond a reasonable doubt. And so we foresee this being applied by prosecutors only in egregious cases, cases where the likelihood of death is so clear that expert testimony is not necessary, that it is clear even to a casual observer that the intent was to kill the animal by neglect, deprivation of food or water, exposure to the elements, exposure to animals in a way that the animal, that the dog or cat, the pet is unable to protect themselves and unable to provide for themselves. It seemed to us that type of a slow, lingering death may not strictly fall under the word killing as it's used in this statute, but it should fall under the term torturing as it's used in this statute, and that's why we've proposed making that amendment.
Thank you for your assistance, Mr. Bailey, and thank you, Mr. Chairman.
Any further questions? Representative Schreiber.
Thank you, Mr. Chairman, and this is for any of the proponents, but more out of curiosity, how widespread is this issue across the state? I know we've had some the last year or two down in Lyon County, but I don't know if this is something that occurs frequently that needs to have this statute change, but wonder if anyone would like to address that. Thank you.
I can, sir. Again, this is Christy Fisher. Speaking from Sedgwick County, just off the top of my head, I can think of at least 5 or 6 cases that have occurred here in this jurisdiction that would fall under the parameters that we're describing here in the last 6 months alone. And that's just the ones that I'm privy to. I'm sure there are quite a few more. In my history as an animal cruelty investigator and a law enforcement officer that worked animal cruelty cases here, this is a pretty common occurrence, unfortunately.
Okay, not seeing any more questions. We'll move on to our next proponent, Nika Orbaugh.
Mr. Chairman,
Yeah.
I have a question.
Yes, I'm not sure who just asked that. Okay, Representative O'Hobbison.
Thank
There
you.
is the hand. It's blending in this year. I don't see it in the corner of the screen. Sorry, guys.
Thank you, Mr. Chairman. My question is with respect to the definition of animals. Are we just talking about just pet animals, or is just like a wide, from the example that the attorney Rick just mentioned about dogs and cats? Are we just talking only about pet animals, or is this like, pretty much everyone in that category? That's just, I'm trying to clarify this, what I'm hearing.
The way the statute currently reads, Section A1 applies to any animal. Now, there are exceptions later in the statute that deal with, for example, dealing with pests, rodents, those kinds of animals. But currently, as the statute reads, knowingly and maliciously killing, injuring, maiming, torturing, burning, mutilating any animal would apply to not just pets, but any animal.
So does a person have to own the pet, or is it just kind of like a random act? And I'll give you an example. Say, for instance, there is a walking dog or a walking cat in inner city Wichita, finds a home somewhere, and that person is not a pet person. And you know what? They don't want to take care of it. It's not theirs. It's not their problem. And the people around, I've seen this pet in that particular premise. They assume that that animal belongs to that owner, but it doesn't. So say, for instance, if the person doesn't care for it and something happens to it, does the prosecutor say that, hey, you know what, since it was in your premise or property, you were you neglected it, you caused it to die, and they decided to get charged. Is that a fair assumption? Or I'm just trying to understand, like, what is the criteria here?
Sure. First, the animal does not have to be owned by the defendant in the case. But secondly, again, it's important to keep coming back to the current language in the statute that the action towards the animal has to be knowingly and maliciously done. Both currently as the statute reads and after this amendment, if someone is simply failing to provide an animal with food or water,
even though they don't own it.
Even though they don't own it, that does not constitute a felony. And under this amendment,
if it just wanders into their home and their property, and they're like, if I don't care for it, the pet probably might go somewhere else, and the pet doesn't. And if it happens, then you're saying that if the pet dies, wherever it was, I mean, the prosecutor could charge whoever it was that, or the last place that the pet was. Is that my understanding?
That it could possibly be charged as a misdemeanor. It would not be within the scope of this amendment. And the reason this amendment requires confining or restraining is important, because what the act of confining the animal or restraining the animal does is it prevents that animal from taking action to care for itself, to get food or water elsewhere, to find some place where it can protect itself from the elements. So if you just simply have a feral cat that is coming around your back door, and every now and then you put a can of cat food or tuna fish out there to feed it, but you quit doing that and the cat no longer is being fed by you, that would not fall within the scope of this statute. First, you haven't done anything to restrain that animal, to prevent it from caring for itself. And secondly, you don't have any malicious intent. You're not failing to feed the animal because you want that animal to die and you're trying to hasten that along. So that type of situation doesn't fall within the scope or the intent of this amendment.
To clarify that, because I keep hearing dogs and cats and the whole animal. I'm just trying to clarify, but I do appreciate your testimony on that. Thank you.
Thank you. We will now move on to Ms. Warbaugh.
Oh, I can unmute myself. Hi, my name is Nika Orba. I've been in the animal care industry for 15 years. I'm currently the supervisor of Sedgwick County Animal Control, but I'm here today to testify on behalf of the Kansas Animal Control Association. We are a self-governing body of animal control officers and animal care personnel that are throughout Kansas. And we hold trainings and continuing educations for different officers. We became aware of this bill as we're all pretty active in the animal care industry. Being in Sedgwick County, I brought up the bill to the board, as did Midge, to talk about it the other night. Everyone was strongly in favor, which is what precipitated my testimony in writing, which I believe you all have been given. I will speak just briefly. I don't want to go over what everyone's already said. This is a very widespread issue, very widespread. In 15 years, I've seen dozens of cases. As recently as 3 weeks ago, my department picked up 2 dogs that a gentleman fully and knowingly stood on body camera and told us that he tied out at an abandoned house because he didn't want to deal with him anymore. He didn't have the money to feed him. He didn't really care. And when he was asked if he knew they were going to die, he said, well, whatever happens, happens. He knew no one was going to that house. He knew no one would be in the area. He knew that they had no access to food or water. And he tied him out there on purpose. The way the current statute is, if we have a very zealous prosecutor, we might get a misdemeanor out of it. In this case, it was kicked back down to my office, and that gentleman received $150 in fines. So that's not right. What happened to Bowie isn't right. The dog I pulled out of the trash compactor that was paralyzed from the waist down because he was thrown away in a church garbage isn't right. I would encourage you to realize that this is widespread and very demoralizing to the people in the animal care industry. And even when the owners don't care about their dogs anymore, I think it would behoove the legislature of Kansas to show that we do. We do care what happens. And as Midge pointed out in her testimony, someone who will knowingly and with no feeling do this to an animal has very little issue doing this to a person. And it does happen. Frequently, more frequently than I would have time in the day to sit here and give testimony about. with that, I'll wrap it up. If anybody has questions, I'd be happy to say more, but basically I agree with all the proponents so far. Everyone's done a positive job, in my opinion.
Very good. Committee, any questions? Do not see any. We have written, I believe written, right, Justin? Just written testimony from Northeast Kansas Animal Welfare Foundation, so please read that. Anyone else online or in person as a proponent? Okay, anyone here is a neutral conferee? Opponent testimony, we have written opponent testimony from the Kansas Livestock Association, so please read that. Anyone else as an opponent? Okay, we'll close the hearing on 2364. Committee, I realize we are supposed to be on the floor at 4:30, but I just checked in, and surprise, surprise, the Senate still has a long time to go. So, and they can't start without us, because this is our bill. So we're going to continue forward with this next bill hearing and open the hearing on House Bill 2299. Have Natalie give us an overview. This is a bill that we actually heard early last session, February 15th of last year. Going to do another quick hearing just so you're all refreshed on it in the event we decide to work it here at some point in time. So, Natalie?
Thank you, Mr. Chairman. House Bill 2299 allows a search warrant to be executed within 10 days from the date of issuance. So the bill amends KSA 22-2506. That's the statute that provides all the requirements for executing a search warrant. Current law requires those search warrants to be executed within 96 hours of the time that the warrant was issued. This bill would amend that to require that search warrants be executed within 10 days from the date of issuance. And I can take any questions.
Do we have any questions for Natalie? Do not see any. Thank you. Proponents, we have one in-person proponent. Ed Klump's here today on behalf of his 3 organizations.
Thank you, Mr. Chairman, committee members. My name is Ed Klump, and I'm here on behalf of the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and the Kansas Peace Officers Association. And I appreciate the opportunity to speak on this today. As the chairman said, we testified on this last year, and we fully support this bill for several reasons. We did some research on what other states were doing, and that's laid out in my testimony. We only found one other state. I understand there's more. We didn't find the statutes in every state with our search capabilities. We found one other state that had a 96-hour limitation. By far, the most common is 10 hours across the country. We looked at the border states, and all of the border states except Colorado have a 10-day period to serve search warrants. Colorado has 14 days. And likewise, we looked at the 10th Circuit states, the circuit which we're in, and all of them have 10 days except Kansas and Colorado, again, 14 days. So it's clear that the standard around the country is 10 days. There's several reasons for that we think this is a good move to do. And I know Representative Ressman, who requested this bill, was hoping he could be here today also, and of course he can't. But it was actually started discussing, the discussion started on it because of the suggestions about no-knock warrants. And one of the ways we thought we could address reasonably the no-knock issue is to have more time to serve the warrant, because that gives us more time to find a space in time where we can make a better and more targeted approach to serve a warrant, and to make sure that, take steps to confirm the evidence is there that we're looking for, and also give us opportunities to look at other alternatives than serving a search warrant where we're going to have forced entry when the people are there. And oftentimes, if we have enough time, we can put the place under surveillance. We can see when those people leave the premises. We can stop them, detain them, and then serve the search warrant without having to make entry with people present in the house. So that's one of the hopes that we want to do. And we believe that the 4 days is
sometimes restrictive, and we have cases where we have to go back to the court and renew our request for a search warrant because things didn't work out where we could serve it within the 4 days. It'll stop that workload on us, on the prosecutors, on the courts. And so we would recommend you pass this bill forward favorably. And I'll stand for questions.
Any questions? Do not see any online or in person.
Bless you all.
That's because Representative Carmichael's softer, nicer, friendlier. John, your testimony is just written, correct? Okay, so committee, we also have written testimony from the league. Please review that. Anyone else as a proponent? Okay, any neutrals or opponents? Not see any. We'll close the hearing on House Bill 2299. We are not going to work any bills committee, despite the fact we still have 14 minutes. That was quick. We'll do those next week. Next week, we do not have a meeting on Monday. We're still trying to get bills in. We've got several requested today, so we'll see where those end up. A revised agenda will hopefully come out tomorrow. I'm going to add the CSO bill. It'll be on Tuesday, and then on Wednesday, we're going to add 2447, which we actually, well, we officially had a hearing on that last year, but we didn't really hear it. It's the security fee fund sweep. It's a result of some litigation. We'll hear that next week on Wednesday. So we'll have 2 bills Tuesday, 2 bills Wednesday. And so that's it at that point. Thank you all. We'll see you all on the floor here in a little bit. Have a good evening. We are adjourned.